You're listening to Members of the Jury, the show that takes you straight into the trenches of justice, where the passion, players, and consequences are real. Each episode, we examine current events happening in the system. From the battles in courtrooms to the streets demanding reform, we bring those stories here to you, the members of the jury, because we aren't afraid to take it to the box.
What's up, members of the jury? Welcome back to another Freedom Friday episode where we will be breaking down a fantastic verdict result by our guest today. We are super excited to get into it. Like always, the plan of the goal is to hear amazing advocacy and hopefully to learn a little trial tip, trick, or nugget that we could lead to our own successes here in the future in our own cases. So I'm really happy and excited to get into this case. From my understanding, there's definitely some wonkiness to it, which I'm really excited to hear how that plays out. And so joining me today is Defense Attorney Jaime. Jaime, please introduce yourself to the members of the jury.
Hi, my name is Jaime Wiley. I'm a trial attorney doing criminal defense in the state of Utah.
And Jaime, we're really fortunate and it's a pleasure to have you join us. I'm really excited to hear about this trial. We always love when we can highlight our private defense attorneys or public defenders in our space, because it's always the side that nobody wants to talk about, and always highlight how it's not a just verdict when in actuality, arguably, it is the most just outcome when you have your constitutional rights fought for and your day in court and things work out the way that you do. So why don't you give us a quick rundown of the facts of your case and a little insight into essentially why this case found itself going to a jury trial?
Absolutely. So I represented a client. I give him permission to talk about this case, but for privacy, I'll just call him T. I represented a client on two cases. One we went to trial and one we got dismissed before trial. Now, the one we got dismissed is relevant because it had to do with the prosecutor's reasonableness as far as dismissing the second. I firmly believe that my client was innocent of both charges. They are both misdemeanor cases. So the first case, which we ultimately got dismissed, was unlawful detention, Class B misdemeanor. The allegations there, and it was still they were pretty wild allegations in that case. Essentially, this girl's car broke down in my client's apartment complex. He states that she was crying in the parking lot. He came up to her and said, "Hey, we're all friendly around here. If you need a ride to get your vehicle or anything to the impound lot or anything like that, just let me know. Here's my number." He high-fived her and left. We had texts where he was like, "Hey, just let me know if you need a ride. This is T." He says his name, everything. All of a sudden, 4 hours later, she contacts the police and claims that he was forcing her to stay there. He was hugging her and not letting her go, and he brandished his gun. Now, my client was a veteran, and he open carried. And so he swears up and down that he never brandished his gun. It was just on his side, which was allowed. And just the facts of the case leading up to it, where it just didn't make sense. She claims in her statement that she was so scared of him that after he finally let her go, she had to run home and lock her door. Well, if that was the case, why did it take 4 hours to call the police? So that didn't really add up.
Let me ask you something while you were analyzing those facts, because I'm always so intrigued with kind of gun laws and just general feelings and nature of facts where there's a gun involved, but in a state where, especially one like Utah, where it's open carry, does that do anything to you? Because I know, like for me, when in California, where there's definitely no open carry, concealed carry. Like anytime someone's out in the public and there's a mentioning of a gun, that always gets my direct attention, just because I know how much it elevates a situation.
I could see that in Utah. The culture here, and it depends on the area, but for the most part, the culture here is a lot of people, if not the majority of this state, are hunters, veterans, etc. So gun culture here is just very people have guns and people know that. We have a fairly safe state. And I do think that's because most people here carry guns and we can protect ourselves. So to me, when I hear a gun, it's the facts surrounding it that concern me. Just seeing that somebody has a gun is so normal here that it doesn't stand out as atypical at all.
Okay. So you have the situation with your client and this stranger where you've obviously highlighted some, at least initial issues with her statement. And that case, ultimately, those set of facts ultimately to your client's first case. That's right?
Yes, this is the one that was dismissed.
Okay.
I had filed a what's called a Tiedemann motion, which the officer never activated his body cam while interviewing either my client or the alleged victim. And so I challenged that. I wanted to exclude any statements made by the alleged victim that were not written. And I honestly think the prosecutor just didn't want to respond to this long motion. I also think that he may have had an issue contacting the alleged victim as a witness. And so he ultimately dismissed that case. The reason that case is relevant to the second case that we went to trial on, I believe it was about 2 months later, my client was he lived in this apartment complex that was like basically a U shape, and there was a pool and a hot tub in the middle of it. And a lot of people would drink there after hours and just, it was kind of a little party spot for that town. And so the incident that led up to the trial was there was a physical altercation that happened that my client was involved in, where he ended up knocking a guy out.
And this was at the apartment complex?
At the same apartment complex, yes.
Okay, because that's where he lives.
Yes, he lived there.
Okay.
So I don't know if you want me to jump into all the details of that night or kind of tie in why it was relevant to the first case.
Yeah, I think, let's start kind of with the relevancy of connecting them, because where I'm thinking is that, and I want you to continue going down with the facts of the case, but I can already imagine basically the prosecutor saying, regardless of what facts you're about to tell us, the fact that your client got a quote unquote break of a dismissal on the first case, he wasn't going to bend over and let that happen again.
And that's exactly what happened. So even though we had such strong evidence for self-defense in the second case, because the prosecutor dismissed the first case, he just outright he wouldn't even entertain what's called a plea in abeyance. I don't know if that's typical in California or other places.
No, what's that consist of?
So a plea in abeyance in Utah is for certain crimes. A few were not available for, or there are a few crimes that this is not available for or allowed for. The plea is you plead guilty, and it's basically held in thin air, so in abeyance, until the defendant completes certain requirements like probation, fines, etc. Once all of those are complete, then the case is dismissed with prejudice. So it's a guilty plea that is entered, and it results in a dismissal later on.
Got it. Yeah, no, actually, when I first began practicing in California, we did have something similar to that. What was a version of like court diversion. But actually, roughly 3 years ago, our legislator enacted a legislation that has now a pre-plea diversion, especially on all misdemeanors, where it basically any defense attorney can just kind of negotiate whether or not the individual deserves diversion with the court. The prosecution's objection to diversion is like inherent in the bill. So,
interesting.
Yeah,
okay.
yeah. Because it basically says the court, its own discretion, can grant diversion even over the people's objection. Whereas because I think previously when it was a plea requirement, that was something the prosecution did have to agree on as well. So, I've seen so much success and successful diversions with that pre-plea that we have. But that's awesome to hear that there's a way still within Utah that ultimately people can earn dismissals, because I think that that's a great outcome. And I always tell clients, anytime you can put the outcome of a case in your own hands, whether you kind of agree with how you got there or not, is the best decision to make.
No, absolutely. I agree with that. I do wish that Utah had something similar where we could put it to the court rather than the prosecutor's discretion. But I don't foresee that happening anytime soon here. So
yeah, that's unfortunate. And it was surprised it would get here, but I mean, hopefully that's something that can pick up in the system, because, the whole method of carrot and a stick wasn't working. And so to try something new, it seems to hopefully, I think, catch nationwide success. So let's get back to the second case. My understanding was that your client was at his apartment complex again, kind of hanging out generally in the common area, pool, bar area. And he was basically accused of, well, give me a little bit more detail as to the physical altercation that ultimately led to the charges.
Okay, so the physical altercation happened. The alleged victim, but also the alleged victim was also charged with assaulting my client that night. So I'm just going to call him K.
Hold on. Hold on. Let me interject. I just want to make sure I understand that. Your client got into a fight with another individual.
Yes.
And then the prosecution charged both individuals in the fight for fighting each other?
Yes.
Okay, this is fascinating. Please continue.
It gets better.
That sounds so insane to me because in general you have to have a assailant and a victim, and you're not going to charge your victim with also being an assailant. So I'm just trying to make sure I'm following correctly. Yeah. And I totally get that. Okay.
Yeah, this case gets pretty interesting as far as some of the rulings that were made. And I'll just give you a little nugget. Later, when the police testified, they came out and told my client they hope it got dismissed, which I thought was really funny. They really liked my client and didn't want to see him found guilty, even though they were the ones who cited him. So, pretty interesting case all around. So T is my client, K is the alleged victim, but I refer to him as the initial aggressor throughout the trial. So I obviously would not refer to him as the victim in the trial, especially in this case.
Doesn't sound like the prosecution did either.
I'm so excited to talk about this case because it just keeps getting more entertaining. So my client gets charged, so my client's sitting at the pool. Now, T and K knew each other from some prior altercations, which I will get into when we talk about Utah's self-defense law. So in this particular instance, my client T knew of K and knew about his prior violent tendencies. This kid was pretty well known around the apartment complex as being a violent guy. He didn't even live there and had been trespassed from the apartment complex property multiple times before this night. So by all witness accounts, K was just absolutely drunk, like just obliterated out of his mind. He had finished, if I remember correctly, the witnesses testified that he finished a half gallon of vodka to himself while he was sitting there.
Wow.
And he's so he's a skinny guy. He's pretty tall. But he was, I want to say he was 19 at the time, 19 or 20, but I know he was a younger guy. So he's just obliterated. And he's sitting in the hot tub. My client was in the corner of the hot tub by himself. My client was having a couple of beers. And from all the facts in the case, whether it be witness testimony or anything like that, there was no debate or disagreement that K started the initial argument with everybody. So what came out was K starts bad-mouthing some of the women who were there. He wasn't with those women, but he starts talking a bunch of crap to them, saying really disrespectful things, some sexual things. And my client T, again, he's a military veteran, very, very all about respect of women. And so he became offended by some of these comments, told K to stop. K apparently stands up, starts yelling at T. And at some point, he puts his hands around my client's throat and starts strangling him, trying to push him down into the water. So another guy, a witness named M, he comes up behind K, pulls K out of the jacuzzi. K turns on him and he starts trying to attack M. So in the middle of this, M pushes K. K kind of stumbles back. T, my client, is out of the jacuzzi at this point and his neck is bleeding because of K's nails. So this is where the facts differ as far as witness testimony, etc. My client's point of view is K is sitting here trying to fight M, and he turns and goes to punch my client. So my client hits him once, just drops him. I have to say, it sounds like it was a fantastic punch. I did later argue to the jury that you can't convict my client just because he's a good hit.
Right.
And I think that resonated with them, to be honest. So he punches K. Kay is just knocked out cold. Now, that one fact is where all this came down to, the entire trial. The state's argument was that Kay was walking away and my client ran up. This was their actual argument. My client ran up behind Kay and from behind punched him, but somehow landed the punch to the side of his face from behind. So I guess there's some question of like, was he turning because he heard my client run up? That would have been my argument if I was the state. They didn't really make that clear at the trial, but I think that's what they were going for. And so it really came down to, was he walking away or was he coming to hit my client again when my client threw the punch? And there was one prosecutor on the case at the very beginning. It took us about 1.5 years to get to trial. If I remember correctly, I want to say it happened in June of 2020, but it could have been 2021. So in Utah, all criminal trials were shut down for, I think, 2 years. So we were really far behind. So even though this was just a criminal misdemeanor case, it took a long time to get to trial.
That sounds, during the year of 2020, that doesn't surprise us. And, I think courtrooms across the country experience that kind of backlog. And, that's essentially what birthed the creation of this show, is that if the courts weren't going to allow us to, get justice, we were going to at least amplify the justice that, our fellow defenders have been able to achieve. So when you said those days, it didn't necessarily surprise me, that especially since, misdemeanors are at the bottom of the hierarchy as far as, necessity of getting trials out. At least they were for us. That doesn't necessarily surprise me. But the fact that your client was willing to endure the burden of kind of having a case within the system for that long and still willing to fight it is kudos to him, because a lot of times, and arguably by design, the burdensome of the system is what leads people just to plea because they don't want to deal with things anymore. So I love the fact that he stuck with it and ultimately got his day in court.
There was a point in time that he was so frustrated after about 1 year that he finally said, they haven't offered a plea deal or a plea offer, but I'll just take something at this point. I'm so tired of this, because he was trying to get to Florida. And so I did reach out multiple times and I tried to get what I just explained, a plea in abeyance. Should have absolutely been offered in this case. My client had no prior criminal history. It was a simple assault. And the prosecutor said, absolutely not. And he said, I quote, "This was an egregious assault," which is fascinating to me because it wasn't egregious.
Well, it was also a misdemeanor. So
yeah, exactly. So it was one punch. And
like, what's he say to a felony assault if a misdemeanors are egregious?
Exactly. How do you describe
you've capped out, buddy? Like,
yeah. So he would not offer it. And then by the time that offer came back around, my client was so essentially pissed off. He was like, no, they made me wait 1.5 years. Now we're ready for trial. I've paid you to prepare for trial. Let's get it.
Yeah, good for him.
And they missed the window where my client would have taken a plea offer from desperation. And I always advise how confident I am about trial. And, as a defense attorney, you can never be too confident, obviously, but you have a gut feeling of how certain trials are going to go. And this is one that I felt strongly about that we would win. And so I was kind of hoping he didn't take the plea because I wanted to take this to trial and clear his name. And so I was glad that he ultimately said, screw you, you put me through this for so long, like, let's fight,
That's a great segue to my question that I wanted to get to. So take me to like the eve before trial. And I know that you had a really positive attitude about this case. You had a lot of eagerness about that. But at the end of the day, there's still a criminal complaint that your client's facing, and you never know how a jury is going to react. On that eve before trial, what would you say your biggest hurdle or stressor was about the case?
To be honest, it was two things. The first was, so a few weeks, actually probably about a month before we went to trial, maybe 2 months, a new prosecutor came onto the case and took over. It was a smaller city, and so there's 1 to 2 prosecutors per office in those cities. And he came onto the case. He reoffered the plea offer. My client didn't want to take it. He even offered to amend it down. My client didn't want to take that. But he called me about a week before trial. He kept calling me, which kind of gave me a feeling that He was not very confident in the state's case because he was trying to peacock me. And I think as an attorney, you get to know when a prosecutor is confident and when they're being too confident. And a lot of times when they're being too confident, I think that it's safe to say that they're really scared and they're hoping that they can peacock you into a plea. And it seemed obvious that that's what was happening in this case. Is he had a feeling he wasn't going to be successful, and he was hoping he could kind of bully us into taking the plea. But what did make me nervous is a few days before trial, he said, well, we talked to one of the witnesses and we found something out that is really going to hurt your client at trial. And I was like, okay, what is it? And he goes, well, you can call the client and ask. I was like, or call the witness and ask.
It's not how that works.
Yeah, it's not. And yeah. So he's like, but he argued that he didn't have to disclose certain statements that were made. And at this point, we were like a few days before trial. The judge had made it clear he really didn't want to hear too many pretrial motions at that point. I did a motion to exclude because the prosecutor failed to disclose evidence and things like that. And the prosecutor argued, well, I'm really busy. And I said, welcome to being a lawyer, so am I. The judge, my understanding, and I could be wrong about this, but the last I had heard, and when I looked into this, if I remember correctly, the judge was a police officer for many years. And he's known for being very, very, very pro-prosecution. So this is a judge that I don't want to anger before a trial. And even with that, we got some pretty insane rulings during trial. But I felt like if I tried to push the prosecutor to tell me whatever this fact was, that it wasn't pretrial motion appropriate. And if it came out during trial, I could either object to it or request a mistrial if it was really that bad. So I felt the fact that he wasn't disclosing it couldn't have been that big. But I was still a little bit nervous. And I called my client and I was like, you need to be completely honest with me. Is there something I don't know? And we went back and forth, and I trusted him at that point. But my second concern was my client. He is a very talkative person. And we knew that he was ultimately going to have to go on the stand for the self-defense claim. But he talked a lot, and he also isn't a big fan of authority. And so I was a little bit worried that during cross-examination, he would get so frustrated, he would call the prosecutor to F off or something. That was my biggest concern. We had to really sit down and talk about how he could control his frustrations with the case, and if he felt attacked, understanding how the jury is going to take any of his reactions. And I think once I was, as a defense attorney, a big portion of what you need to do at trial is control your client, their facial expressions. Juries are always watching how they're reacting to anything. And so a good defense attorney is able to figure out their client's personality and how to advise them appropriately. So the way that I took working with him and his testimony was basically making him understand that he controlled the room. And if he could control it and he could control his reactions to the prosecutor, then it was his game again, and that really resonated with him. And I think in his head, he was like, oh, if I'm calm and I frustrate the prosecutor or I don't give them it, then I ultimately win. And that really worked for his dynamic. Does that make sense?
Very much so. And I think that those are two valid concerns to have, especially in self-defense cases. Oftentimes the only way to really establish that type of evidence is through your clients. And, there's not a whole lot of ways to kind of practice exactly how the testimony is going to come out. And I couldn't agree with you more that jurors love to pick on that nonverbal communication. And what people don't realize is that the majority of communication is nonverbal. So that's something that we always harp on and preach. And, it's easier to do that when they're sitting at counsel table with you. It's another thing to do it when they're, 20 some feet away from you by themselves on a jury stand. So I think you've done an excellent job of giving us basically a breakdown of all the facts, some of the difficulties that you were looking into. Take us to the opening statements. What was it that the prosecutor did in their opening statement to try to sway the jury that this wasn't going to be a case about self-defense?
I laugh about this because, I would actually like to go over jury selection really fast. Jury selection is one of my really weird talents that I discovered, and I love it. Where you start the case, in my opinion, is jury selection. You can start winning over the jury as soon as you're going through voir dire. And this is how I take every single case. I think with being on the defense side, even though there is a presumption of innocence, I think that a lot of times the jury views your client as a criminal, right? Before all that is explained. So I always take the time during jury selection to make myself seem personable and my client. And so I use, even if I don't care about the answers to the questions that I'm asking, I use it as a point to start showing off my personality and kind of getting buddy-buddy with the jury. And so I'll make little jokes with them, or I'll just chat with them. And it really makes them, the prosecutors usually don't start with that. They're asking very serious questions and they're very stern. And then I come in and I'm just chatting with them, and I really kind of start winning them over.
So in Utah, when you start your voir dire process, the prosecution goes first?
It depends on the court. So
oh, interesting.
Yeah, so a lot of courts will have just set questions that are asked of all of the jurors. The prosecutors are usually, if they have questions, either the court has already asked them, or they don't think I'm going to use voir dire as a chance to get to know the jury. So for me, most of the time, I start it anyway because the prosecutor passes it. And once they realize that I'm using it as an opportunity to win over the jury, then they have follow-up questions.
Yeah, that's fascinating. In our process, it's embedded that the defense attorneys go first. It's the only time in the process where we'll go first, but we get so all judges generally have some type of court veneer where, they have a questionnaire of some sort, but then judges have the discretion to give you somewhere between, 10, 20, or, depending on the seriousness of the case, an infinite amount of time to do the voir dire. And so it's just so interesting to me because I agree with you 100% that, you got to be personable to have effect on a jury. And so that's just so super interesting for me to hear that that's not kind of a universal thing. In fact, we actually have there's an attorney in our office who's a former veteran, and he always tells a personal story about his service during his voir dire. And it got so bad or so detailed that the prosecution started filing in limine motions against him in all of his cases to preclude him from telling personal stories to the jury.
I hope that I can be such a good defense attorney that prosecutors instantly know and want to file motions.
Yeah.
He's a damn good defense attorney.
Yeah.
It's amazing.
So that's good. So talk to us a little bit about that voir dire process. At the end of it, did you ultimately feel good about the jury you were able to select?
Yeah, actually, there are a couple that I questioned. Now, one thing I did, which was a little probably, it wasn't shady. It was my right, but I'll say it. I think it probably bothered the prosecution because it was very strategic. At the end, the very last question that I asked, and I just posed it to the whole jury, I said, is anybody here opposed to self-defense claim? And so that initially, before the prosecutor had a chance to stand up and say, oh, here's this violent assault, it's already in the juror's brain. Well, we know that there's going to be a self-defense claim. And I really enjoyed that. I saw the prosecutor's face and they were not happy at all. But I think it was a good tactic, and it got that little seed of reasonable doubt starting.
I think that's a perfectly valid voir dire question. If someone were to be on your jury and be like, there's never a situation in which self-defense is permitted, you should be entitled to know that. And because obviously that person wouldn't be fair and impartial to a jury. So I think that that's a fantastic question. I wanted to imagine the judge did as well. The prosecutor probably didn't like it because he realized it was such a good question, and we were really going to get a sense as to how these jurors felt. So kudos to you.
Yeah, thank you. So what I found interesting is, so they had two prosecutors in this case, and I think one was a student. I'm not entirely sure, but I do know he was brand new. The reason I know is he had that very cocky attitude of somebody who has not had the system beat him down at all. So and then there was the kind of lead prosecutor who was a little more humble, but still kind of cocky. And so they seemed like the type who were very good law students, but probably didn't have as many social skills as you need to be a trial attorney. So there are lawyers out there who are geniuses and who could do a million times better than me as far as briefs or research or anything like that. A trial attorney has to have a personality. If you come across as a dick, a jury's not going to, especially in defense, you have to be personable again.
Well, and unfortunately, even particularly a female in defense.
Yes.
That's what I'm gathering that as well. What might be seen as, a zealous advocate as a male who's really grilling someone, a jury wouldn't be that uncommon for a jury after the fact to be like, well, I thought you were being bitchy or angry or whatever thing for a female. So yeah, I definitely see that space.
Yeah, there was a cross-examination in this trial where I started getting nervous that that's how the jury was feeling. And I'll get to that. But I think for me, I don't know. I try to be a little bit more bubbly. And I think that is because I'm aware of how I will be perceived if I'm like a very strong-headed woman. And then it's because of like being blonde and feminine and things like that. There's a very fine line between bubbly and airheaded. So I don't want to be bitchy. I don't want to be airheaded. And so it's kind of a fun line to try to tread. And I'm sure I've screwed up plenty of times, and so we'll see. But juries do tend to really like me. Like I think I come across as pretty warm beforehand, but that's because my cross examinations tend to be pretty intense. And so I want them to feel that I'm warm before they see that intense part of me later.
Actually, I really like that. And I think I tend to do that without consciously thinking of that, but I'm also a very aggressive cross-examiner. And so taking that advantage in voir dire and even potentially opening to show them that aspect of it, I think, like I said, I think I do it subconsciously, but I need to be more conscious of it. So I like that. That's going to be my tip and trick that I take away from the episode. So yeah, take us back to the openings. Now that you felt that you kind of got the upper hand a little bit by planting the seed of self-defense, was there anything in the prosecution's opening where he tried to emphasize how this wasn't going to be a case of self-defense?
Yes. The prosecutor's opening, this is kind of mean, but I still go back and listen to it and kind of chuckle because it was just such a new attorney opening. He would in law school, I don't know your audience. I don't know if it's people who are lawyers, et cetera, but in law school, there, at least in my class, when I took a litigation class, there was a trial advocacy book that broke down how you're supposed to write everything. And it was as if this prosecutor took every single thing in that book so seriously and just didn't have maybe the social skills to understand when certain things were appropriate. Does that make sense? I'm not trying to be mean at all, but
basically very vanilla and just kind of sticking to the facts.
No, it was actually the opposite. He was trying to set the stage, but in the weirdest ways. So the weather is going to be applicable or relevant if we're talking about something like a car accident, right? Like how the wind was happening, not in an assault case. And so he starts this out, and he had made a couple of rude comments. He wasn't very pleasant towards me from the very beginning of this trial. So he had already been a little bit disrespectful and a little too cocky. I'll admit that my pride kicked in a few times, and I kind of kicked him while he was down a little bit. But so the first mistake he made is he listed the wrong date in his opening and was completely off by it. So then he starts detailing, but it was the most dramatic, detailed opening. He spent, I think, 2 full minutes setting the scene. So he's like, on a dark, dreary night, their wind was passing and hair was blowing. Like, he didn't actually say that, but it was basically that dramatic. And it was just this really awkward, you could tell he was setting the stage, but he didn't understand what was important about the stage that he was trying to set. So he goes through this very flowery, detailed opening argument and just really didn't hit many of the facts, except he said the key that I picked up on is he described the assault against my client as a slight altercation, were the words that he used. So I stood up and instead of being flowery and detailed, I just went straight to the point and I went straight to what the law was, basically. So I stood up and I corrected the date. That's what I meant by kicking him while he was down. I said, so actually it happened on this date. And then I set the stage, but it was here are just the plain facts. And when it got to, my very opening statement was like my first line was essentially, this is one of the most clear cases of self-defense and defense of others that you're ever going to see. And so then I go through the fact just step by step. And I said, I find it interesting that the state calls it a slight altercation, because what Kay did is he strangled my client to the point that my client's neck was bleeding. And I said, and as a result, he punches him, etc. So then I end it with reiterating, this is one of the most clear cases of self-defense and defense of others that I've ever seen. And I'm confident you and the jury will feel the same as once we are done. And you listen to those two opening arguments, and it's very clear that one was trying to be flowery because they didn't have the facts on their side, and one was just straight to the point. And I think that the way that I did it in that case specifically was just, I think the jury saw it as one was less experienced than the other. And I think it worked in our favor. I usually don't feel that way in cases. This just happened to be a case where the prosecutor was very clearly new. So I'm not usually cocky, even though I seem like that right now, but it was just kind of a mess of a case. And it gets worse. I'm really excited to tell you about the closing argument when we get there.
Well, yeah. So give us a rundown of the prosecution's case in chief. I mean, I gather that they're going to call cops to come testify to what they showed up, and they're going to call their alleged victims. Were you surprised by any witness that they called? Do you think that they called some of the specific bystanders over other bystanders?
So the alleged victim was not there, because he had a warrant out for his arrest in that court after pleading guilty to assaulting my client that night. So
that's so insane to me that you have.
Oh, it gets even funnier.
It was so ultimately the alleged victim's assault was against your client. Not even. I was started to think it was against M.
No.
Oh my God.
No, it was against my client. And he pled guilty and then didn't show up for sentencing and had a warrant put out for his arrest.
Well, now I have another question, though. How does this not violate your client's constitutional right to confront his accuser if the victim wasn't there to testify?
Exactly.
I'm sorry.
Yeah. So we had a few arguments before the trial started. I was overruled on every objection I made prior to the trial. So the prosecutor wanted to argue about so at the very least, and maybe this is where I was a little too confident, I thought there was no way that the judge was not going to allow the fact that Kay was convicted of assaulting my client that night. Judge did not even allow that. And the argument that the judge accepted was that it would prejudice the state's case, which is mind-blowing to me, because the truth is not prejudicial to the state's case, right? Like, the state is not an entity in this. And all of those arguments were overruled ultimately. The only thing that I was allowed to bring forth to the jury was that both of them were cited that night for the assault. I could not say that he admitted to assaulting my client, pled guilty, anything. If we would have lost, there would have been an appeal. It was in a justice court, though, in Utah. Justice courts. So we have justice and district courts. So in justice courts, you get an automatic appeal up to the district court. So we would have had a second bite at the apple. And I'm confident that the district court judges would have not made the same rulings. And so because we ultimately won, I didn't get challenge those fantastic rulings, but I'm still not happy about them.
Those would have, I'm flabbergasted just in hearing those. Was there anything in your cross-examination that you really relied on ultimately in this case, or was it more so really establishing your arguments through your case in chief?
So what was interesting is that the state called 3 witnesses, and 2 of them we were going to call. So M was an obvious one, and then there were 2 women. One was B, and I can't think of the other one. But one of the girls I didn't want to call because in reviewing the body cam, she was more interested in telling the police that she was a registered nurse 300 times than she was about anything else. And so it seemed clear she wanted her 5 minutes of attention. And when I contacted her before trial, like 6 months before trial, she told me she didn't remember anything. She was like, oh, it was so long ago. I don't remember it. And then all of a sudden she became the state's star witness at the trial. So she starts adding facts in that had never existed. She didn't say the night of.
Gotta love that.
Yes. So it went from my client just punched him in her written statement to then she starts saying that my client was holding Kay under the water trying to drown him. And so this was probably my favorite cross-examination I've ever done. And it had nothing to do with my talent. It had all to do with this woman's personality. So I just started asking her, so where did this come from? And so she starts saying, well, my grandpa's a psychologist. And I know that when you go through a traumatic event, like seeing a really vicious assault, or no, she said egregious assault. And that's when I knew it reminded me of what the prosecutor had said. So she starts saying your brain will remember things after an incident. And so I kind of started making fun of her a little bit in my cross-examination, and it wasn't intentional. It was just, I was like, so your testimony here today is that your brain was making things up? That's what your testimony is? And she confidently said, yes. And so then I realized this big secret that the prosecutor had that was going to come out was she was claiming that my client was trying to convince everybody, like, oh, you saw that he was coming after me, right? Like, so basically the way they were trying to twist that is that my client was trying to convince everybody to lie. My client, and as soon as I heard that, I knew my client well enough that he was probably just like, did you guys see that? Like, he came after me and I hit him, not trying to convince everyone. So at that point, I kind of knew that I had it in the bag. But the look on the jurors' faces while she was like, yes, my brain did make this up. I kind of pushed on that a little bit. And that's when I felt like I'm a little worried that the jury's going to think I'm bitchy. And there were a couple of times she was getting really frustrated with me. And so I did pull back and I said, hey, I'm sorry. I feel like this is getting a little bit intense. I'm not trying to attack you. I'm trying to figure out where these new facts came from. And so I cut the tension a little bit and took it off of like me. Like it was clear that it was her having the tension after that. But there was a tiny bit of a cat fight up there for a second. And I, as the attorney, had to step back and be like, hey, I'm just doing my job here, and I think that worked well.
I was gonna say that's some really good insight too, though, because you want to be conscientious. Again, going back to your earlier point of not only how the jury is interpreting you and the witness's body language, or your clients and the witness's body language, but also you as an attorney. One of the last things you would want is for some reason or some way a juror's hostility or animosity or dislike towards you somehow ultimately affected their judgment in that case or that verdict. So you just tackled the first hurdle that you said that was giving you issues before the case, and that was the secret fact, and seems to have not had been as juicy as the prosecution talked to us or had alluded to. Take us to the second hurdle, and ultimately your case in chief. Was your client the only witness that you called, or were there any other, since the prosecution had called some of the witnesses you were planning to, were there any other witnesses in addition to your client?
I called a couple of the apartment complex residents as reputation testimony for Kay, and they brought up like violence, and he was well known for it. One of them, I specifically instructed, you cannot bring up the gun incident. That's initially why I had him there, was to testify about this gun incident. And he slipped up and said, well, he pulled a gun on him a week ago. And I said, Your Honor, like, all motion to strike that off the record. Was I glad that he said that? Yeah.
Can't unring that bell.
Yeah. So the jury heard it. Yeah, there were the other two witnesses were fine that we were both calling. They both admitted that their testimony was different than the written statement. There were a couple of rulings that I'm still irritated about with the judge with introducing the written statement. But ultimately, the main witness, M, admitted that his written statement would have been more accurate because his testimony was, it was as he was walking away that T hit M, but his written statement said K was coming after me again and then T hit him. And so I was able to impeach him in a very friendly way because he was like, I made no mistake in this. But getting to your question, my client's testimony, this is where the prosecution lost the case. I get up there, I have my client explain the background. He goes through what happened, what was going through his mind. We slowed down the part because they wanted it to seem like it was this drawn out two separate incidents, what happened in the hot tub and the second altercation. So we really drew out the lead up, and then I made the way I directed it was to make it very quick. So it was bam, bam, bam. So he only had a split second to think before he threw the punch. And we really worked on how to do that. And it came across beautifully. Like, it was very clear that he had that quick to think and he punched. Where the prosecutor messed up was he got too cocky, and in his cross-examination, what he wanted to focus on, which I still think is disgusting and offensive, and so did the jury, he starts cross-examining my client and going, well, aren't you a combat veteran? Aren't you trained in, yeah, I know. Aren't you trained in combat?
The fuck?
Oh, yeah. No, it was, and the way he was doing it was so offensive. And this is where T is going to lose it. Oh my God. So I was getting nervous, and T kept looking at me, and I just, it's okay. And he held it together beautifully. The way he testified under this cross, they were like, so you're afraid of a 19-year-old boy, blah, blah, like, you've been to war.
You want to go there?
I will never forget, my client said, how old do you think the combatants are over in Iraq?
Nice.
And
yeah.
I was like, and so then my client, so when I got up to redirect, he said, the prosecution is really harped on you for being scared of a 19-year-old when you're a combat veteran. And I want to give you a chance to explain that. And he went into this beautiful, like, they're 19. I have watched my friends. Oh, because one of the points they kept making is this little 19-year-old grabbed your throat. And my client in the redirect went into detail about how he watched his fellow soldiers get choked to death by terrorists who were 19 years old. And so they thought that it was this aha moment, and they just looked like pricks. It pissed off the jury. You would think that they would have caught on to that, but they did not.
No, I'm offended for you, for him. That's.
Oh, it was so disgusting.
Yeah.
And you've got to realize Utah's a fairly conservative state, very pro-military. So it's like, read the room, man. But none of them did. So my favorite part of the closing, though, so the prosecutors stand up and they keep harping on this fact that he's a veteran and that they can't believe this big veteran would be afraid.
In their closing, closing, they're harping on the veteran stuff still.
Again, yeah. And
okay.
So at this point, I'm like, you guys don't even realize how bad you look, and you're making this easy for me. So my favorite part, though, and I'll never forget this, in the closing, the newer prosecutor, the cockier one, he grabs a law book off of his table and he goes, Miss Wiley would have you do this with the law. And he slams the book, like throws the book on the ground. And I admit that was so unexpected. You can hear on the audio me go, ha! It was just the dumbest thing I've ever seen. And it was so funny. And I finally had to look away because I couldn't help but chuckle. It was the most dramatic thing. And I was like, this guy has no idea. He was so cocky walking in.
That guy watched some movie the night before where they did that. I don't even know what movie that would be, but yeah. That's hilarious.
Well, and this guy in chambers, I had made an argument, and I shit you not, he goes, after I made the argument, he goes, meh.
This is
and
crazy.
I said, did you go to law school in a daycare? And he I said that to him. So that was
Whoa.
yeah, that was the dynamic. And the judge never once corrected his behavior. I had objected to something and he goes, I am offended by Miss White. And it was like, this doesn't have to be this combative, bud. Like, you're not going to be a very good attorney if this is how you approach things. But this case, I think, humbled him a little bit because he thought for sure he'd win. So my closing was basically the same as my opening. I reiterated it. And so then we waited for so they had a juror dismissed because they had a backup juror. And as the jurors were deliberating, they dismissed the extra juror. And so we were outside while my client was smoking. And she walked up and she goes, I really hope you guys win, and left.
Yeah, that's got to be a good feeling.
And I was like, if we have the dismissed juror saying that, we've probably gone. So they deliberated for about 2 hours. I started getting nervous because it was taking that long. And we go back in and we get the not guilty. My client was very
Yay!
And I was so happy because this was such a fight for him. And for him, this was really about his character. Like, he was so angry that his character was attacked for a year and a half, etc. But the most shocking part, not the most shocking part, but the last shocking part of this trial was the bailiff came up to me after and he shook my hand and he goes, thank you for putting those pricks in their place. About the prosecutor. If you are such an asshole that the bailiff hates you, like, you have to, that guy's not going to go very far. Or he's just going to keep getting shut down. I went up to shake his hand after and I was like, yeah, I hope you remember this because it should humble you.
Jaime, that is such a fantastic story. I mean, so many lessons in there as far as, composure, keeping your cool, taking the higher road, and it's part of the game, the adversary nature where you might take your digs and your shots, but at the same time, like, they're not personal, right? Not that I took away. It was the attacks at the job, at the system, what they were doing, and so I think that was such a beautiful breakdown between the facts, the different legal issues that you were able to highlight. There was definitely a lot of humor. So that was such a well-deserved verdict. We love celebrating not guilties, and we've had a great time celebrating you in this trial. The last question that we always end every episode with is we ask our guest, what is the significance of taking matters to the box?
Here's the thing. I am so passionate about being a defense attorney because I'm so passionate about the Constitution. The Constitution is the fabric of this country, and it is the only thing that is standing between us and tyranny. And at the end of the day, people, I think, look at defense attorneys and they look at the system and they see criminals. At the end of the day, that's not what we do as defense attorneys. We defend the Constitution and we defend people's rights. And when it comes to going to a trial, most defense attorneys are not taking things to trial on technicalities or on just to have fun with it. There is either factual innocence, like my client, a lack of any sort of fair plea offer. But at the end of the day, these technicalities are your rights. And if you're accused of something you didn't do, or you're overly charged, that's what I see a lot is my clients are so overly charged for something simple, and they're facing felonies on something that should be a misdemeanor at most. A trial is where your rights are protected and where the system protects the innocent just as much as it protects the guilty, as people wrongly assume. But a trial is there for the innocent people. And I'm very passionate about the cases that I do take to trial. It's very rare that I take one to trial that I don't fully believe in. I am a private attorney now, so I have a little bit more say than I did as a public defender. But it also, my clients are paying me. And so I have to be do you want to waste money on a trial, right? But for me, like, if I'm taking something to trial and I'm happy about it, it's because I fully believe that a jury of my client's peers is going to see that this is not a valid charge.
I love that. In each and every case that we're responsible for, we are outgunned, we are out-resourced. But that does not mean we'll be outworked, outlawyered, and justice will prevail. So thank you so much again for giving us your time and your insight. We really appreciate it. And the best of luck to you in your future endeavors. Jury. That's our show, and I rest my case. Be sure to come back next episode as we take another matter to the box. If you're a fan of the show, go ahead and subscribe. You can also find us on social media at Members of the Jury. If you want to be a guest or have any feedback, be sure to email us at lhursty@membersofthejurypod.com. The information in this podcast is provided as general reference work as a public service. The audience is advised to check for changes to current laws and to consult with a qualified attorney on any legal issue. The use of this material does not create an attorney-client privilege in any fashion with the podcast, the host, or the guest. This information is for educational purposes only, and no one affiliated with the podcast may be held liable for any decision made based on this information.